second element. The proceeding must have terminated in favor of the one who is now suing for malicious prosecution. The court would be really embarrassed if while you were suing me for something, right in the middle of it, I could turn around and sue you for malicious prosecution. What would happen if we both won? What would happen if the jury in my case decided you were maliciously prosecuting me, but the jury in your case decided you were right? To avoid that problem, no lawsuit can be brought for malicious prosecution until the underlying proceeding, that's the one that I'm complaining about, terminates. And it's got to terminate finally, not terminate subject to being renewed again, but terminate finally. And it's got to terminate on the merits. That means it didn't terminate because of some technicality. It terminated because a court decided that there was no merit to that proceeding. The third element is lack of probable cause. You're not supposed to bring a proceeding against someone unless you sincerely and reasonably believe that that person should be prosecuted or should be sued. If you bring a proceeding against me without probable cause, then you may be liable to me for malicious prosecution. If I can prove that the fourth element is satisfied, and the fourth element is malice. Now, in general, malice means a desire to do harm, but in a malicious prosecution case, malice means that your purpose in bringing the underlying proceeding against me was something other than doing justice. When you brought the underlying proceeding against me, it wasn't because you were trying to get what was actually coming to you. It wasn't because you were trying to bring me before justice. It was for some other reason. And finally, damage. Now, some jurisdictions presume damage because any time you bring a proceeding against me, it's probably going to cause me to hire a lawyer, lose sleep, lose time from work, and so forth. But other jurisdictions require me to prove that I actually had losses that were greater than the costs that the court might have awarded to me when I won that underlying proceeding. That's malicious prosecution, and you should know that in most jurisdictions, a malicious prosecution lawsuit can be brought for instituting a civil proceeding as well as a criminal proceeding, but there are some jurisdictions which still hold out and still say you can only sue for malicious prosecution if the person you're suing instituted a criminal proceeding against you or a quasi-criminal proceeding against you. The other member of the family that I call misuse of judicial authority is a tort called abuse of process. Abuse of process is of relatively new recognition, and it's a kind of an amorphous tort because it's defined this way. Abuse of process consists of the misuse of a legitimate process of the court for an illegitimate or improper purpose. It's a rather unusual tort. The best example I can think of is this. There was a lawsuit between a school district and the Teachers Association. They were doing battle about the contract and how much money the teachers were supposed to get. The Teachers Association, on the first day of trial, subpoenaed every teacher in the school district to be in court available to testify as witnesses. Now, the Teachers Association knew very well that there was no way in the world that all 300 or 400 of these teachers were going to be able to testify, but the association subpoenaed them anyway. The reason was that when the teachers were in court pursuant to subpoena, the school district had to hire substitute teachers to cover their classes. In effect, although the Teachers Association had a right to subpoena witnesses, a subpoena is a legitimate process of the court. They were using it for an illegitimate purpose. They were subpoenaing witnesses that they really didn't think they were going to need that day, but they were doing it for the purpose of putting economic pressure on the school district. And so a court came to the conclusion that this was an abuse of process, and the Teachers Association was held liable in tort for the damage that resulted. Abuse of process. That case is the Farmingdale Teachers Association case, and it's in a lot of the torts case books that are used in the United States, so you may have read it or you may be going to read it. Well, the next area that we're going to discuss is products liability, and this area of tort law has become extremely important to the practitioner because there are so many different ways that a products liability case can be brought, and so many products liability cases are being brought in our courts. Before we go any further with it, I want to make sure that we have one thing understood, and that is the significance of that phrase, products liability. Products liability is not a theory of law. Products liability is not a tort. Products liability is like the title of a chapter in a torts book. Products liability really refers to those cases in which a plaintiff seeks to hold a defendant liable for damage that resulted from a product that the defendant had something to do with. So we call it products liability. But there are really three theories that the plaintiff could advance in a product liability case, and those are the three theories that we're going to concentrate on. Let's understand again, products liability then is the name we give to an attempt by the plaintiff to hold the defendant liable for damage that resulted from a product that the defendant handled, manufactured, sold, or in some way dealt with. To illustrate the theories as we discuss them, I'm going to keep referring back to this hypothetical. So let's state the hypothetical first. Plaintiff is eating with a spoon, right out of the jar, a product labeled smooth peanut butter when he chokes on a whole peanut contained in the product. What are the plaintiff's rights against the manufacturer? What are the plaintiff's rights against the grocer from whom the plaintiff brought the product? Whatever the plaintiff's rights are, we're going to categorize them under the title products liability. Now, the most obvious theory that the plaintiff can advance, the one that we already know best, is the theory of negligence. The plaintiff can sue the manufacturer of the peanut butter, the grocer who sold the peanut butter, under a negligence theory. Let's review what negligence means. Negligence is a breach of the duty of reasonable care. So the first question is going to be, did the manufacturer, did the grocer owe the plaintiff a duty of reasonable care? And remember, in general, the word duty in a negligence case is a kind of a shorthand expression for the court's conclusion that because of reasons of policy, a certain kind of defendant ought to be liable to a certain kind of plaintiff for a certain kind of injury that happened in a certain kind of way. Courts look to foreseeability, courts look to relationships, and for the most part, the courts will probably say that because the manufacturer put a product in the stream of commerce, because the grocer put a product in the stream of commerce that was likely to come into contact with the plaintiff. In fact, everybody in the United States eats peanut butter, so it was likely to come into contact with just about anybody. The manufacturer, the grocer, owed the plaintiff a duty of reasonable care. Which brings us to the next question. Was that duty breached? Usually, the question of breach requires us to talk about whether the defendant's conduct was reasonable. What do we know about the defendant's conduct? Well, the grocer sold the plaintiff a jar of peanut butter. That's what grocers do. The grocer could not very well look inside the jar because once the jar was open, the grocer couldn't sell it anymore. So the chances are that the grocer did nothing unreasonable, and therefore the grocer did not breach the duty of reasonable care. So how about the manufacturer? Well, if the manufacturer did something unreasonable, we could say the manufacturer breached that duty of reasonable care, but we really don't know what the manufacturer did, do we? All we know is the manufacturer put a label on the product that said smooth peanut butter, and there happened to be a whole peanut inside. We don't know how it got there. We don't know if the manufacturer inspected or failed to inspect the product. We really don't have any way of knowing what the manufacturer did, and it's beginning to sound like that means we can't make out a case. But wait, what about res ipsa loquitur? Can we say that this is the kind of accident that does not usually occur without negligence, and that nobody but the defendant could have been negligent. Well, I'm going to go for the second element first because that's an easy